First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. Welcome to the First District Court of Appeal and Zoom session. The only case we have this morning is Spradley versus Citizens Property Insurance. I want to thank counsel for getting this rescheduled. And Mr. Bankston, are you ready to proceed?
I am, Your Honor.
You may proceed then.
All right. I've been instructed to let y'all know how much time I would need on rebuttal.
Yes, sir.
And I'll just keep 3 minutes at the end.
Yes, sir. I will try to remind you, but you're responsible for watching your clock.
Absolutely. Absolutely. Okay. Your Honors, I only have a few remarks for you today. I want to say that I think the issue's been well briefed for you. I think I'll have to hand it to Citizens Counsel that I think that they've done a good job of putting the right line and body of cases in front of you. I don't think we have much dispute on what the law is. And there's no doubt from our side that there has been a trend in Florida law to apply these motor vehicle exclusions in increasingly attenuated fact patterns. We don't dispute that at all. And what this is leading to is a doctrine that if a plaintiff is injured through any cause or while inside of a vehicle that was once owned by the insured, the exclusion is going to automatically apply. That's where we're heading to. And what we want to do today is make the pitch for you today why that shouldn't be the case under this particular set of facts. So very briefly, Mr. Ogburn, the defendant, sold a Ford pickup to our client. But before he sold it, he acquired a tire. He acquired the tire loose so he could see the inside of the tire when he acquired it. And from expert testimony, we contend that he would have known that that tire was in dangerous condition. He put that tire on his vehicle and then sold it to our plaintiffs.
Mr. Bankston, it's my reading of the record that he put the tire on the vehicle and he drove the vehicle with that tire on it for several months, like 8 months. Am I right about that?
I believe it may be more like 6 months. So it wasn't an insubstantial period. That's correct. But what we don't allege is that
if he had reason to believe that the tire was defective, I would think he would not be out on the highway with a knowingly defective tire.
We agree that that wasn't the smartest choice of his. We absolutely agree that, and we think that he knew he had a very limited amount of time to operate that tire. We don't believe we certainly don't believe that was a smart choice by Mr. Ogburn. But yes, I can see your point. Is that may be a very good argument on cross-examination for why Mr. Ogburn may have not known that the tire was dangerous.
So there's case law that seems to support your position, but there's also case law that seemed to support the other side of the equation.
I don't dispute that at all, Your Honor.
Yeah, but the part that seems to be pretty persuasive to me is in the policy, motor vehicle liability is defined. And it's defined as the maintenance, occupancy, operation, use, loading or unloading. So it seems like putting tires on a vehicle would fall under maintenance of that vehicle.
Well, the only reason I would dispute that, Your Honor, is because we don't allege that Mr. Ogburn did anything improper in either installing or maintaining this tire. Nothing that he did in terms of touching the tire, putting it on the vehicle, caring for it while it was on the vehicle. None of that do we allege he did anything wrong whatsoever. The only thing that we allege that he did wrong was seeing the inside of that tire during the purchase of his tire and not disclosing that information to our plaintiffs when he sold the vehicle. So from our perspective, his actual maintenance of the tire and the work that he did on the truck, which would in this case would be limited to just installing it on the vehicle, actually placing it on the rim and inflating it.
Well, so selecting the tire and placing it on the vehicle, is that not part of maintenance?
I think placing it on the vehicle is. And there is nothing that he did when placing it on the vehicle or installing or any of that maintenance that has any causal connection to the incident. I will concede to you, Your Honor, that there could be a potential way you could stretch the word maintenance into a decision he makes about purchasing a tire from or acquiring a tire secondhand from someone else. We don't believe that that's an act of maintenance. We believe that that was his purchase of a product. His decision.
So if I go get new spark plugs for my truck, the selection of the spark plugs is not part of maintaining it.
That would be our argument.
Just screwing them down into the spark plug well. That's the only maintenance.
Actually, I think if you look at what we would look at, say the dictionary term of maintenance would be the work performed to keep a vehicle in running order. And we don't believe that the actual selection or purchase of those spark plugs would be an act of maintenance in and of itself. So in our case, we believe For instance, if Mr. Ogburn had improperly installed the tire, if he had improperly mounted it, inflated it, or if he had abused the tire or poorly maintained it from an external perspective while owning the tire during those months, we would not dispute whatsoever the exclusion does apply. But we think under this very limited set of facts, where a person is basically selling a secondhand product and a product that they became aware was dangerous and had never touched or maintained or done anything to that tire, we believe that that sale itself is the act from which the case arises from.
And I should know this, but what is the alleged defect? What defect do you identify in your?
We allege that inside the tire was internally separating, that inside there would have been signs of the tread becoming removed from the tire, and therefore there would have been obvious physical signs inside of the tire, but they wouldn't have been obvious outside of the tire once it was mounted. So that's our position on that.
Okay.
Counsel, let me ask you about the contract interpretation issue here, the interpretation of arising out of. In terms of cases that support citizens' position, one of those is from our court. It's the American Surety and Casualty Company versus Lake Jackson Plaza case or pizza. And I didn't see that mentioned in your reply brief. It was discussed rather extensively in the answer brief. And there we held that arising out of in a similar provision was not ambiguous. We specifically rejected the rationale in Westmoreland and Smith, the cases that you rely on. And I think the issue there was whether negligent hiring fell within the exclusion. And so, again, the facts in your case are different, obviously, but the reasoning seems to be supports citizens' position and not the one that you're advocating. So could you distinguish that analysis for us?
Absolutely. And I think you're correct that what this court had found puts them on the trend that we discussed earlier that will connect this to increasingly attenuated situations. And the reason is because this court and others like it have found that arising out of has a broader meaning than just proximate cause. And if it's not ambiguous, as this court is now held, then that's the standard we're using, that it is broader than proximate cause. But what I would point to is that in Torres Holdings, the Florida Supreme Court really clarified what we're talking about with arising out of, that's saying that it doesn't require proximate cause, but it still does require a causal connection or relationship in some way. And it's the plaintiff's argument that that continuing this trend will push us past any causal relationship. And thus, I do agree that this court doesn't need to find a direct proximate legal cause from the enumerated act and what happened in the accident. I recognize that. But we think that if we apply in this particular set of facts, that is so far from the enumerated acts, that we've lost touch with the causal connection and relationship in Torres. So we actually think that Citizens is correct on the ambiguity issue. And we don't want to have this court reverse its prior holding and find that arising out of is ambiguous. But what we would argue for the court is that arising out of should still, pursuant to Torres, maintain some character of causal connection or relationship. And what we believe in this case is that the enumerated acts in the policy, which are use, operation, maintenance, those things, there is no connection between those enumerated acts. That what we're really talking about here is an act of failing to pass along knowledge that he had, and not any of the affirmative enumerated acts in the policy that would connect him to the accident. And so that's why we think the ambiguity issue, you're right, we did not address that as much in our reply. And that's because we accept the concept that it's not a proximate cause test. But we're here today to try to make sure that there still maintains a causal connection. Citizens had cited in their brief the Novak case back from the 80s. And I'm sure they're going to tell you today that all that is required is some nexus between the motor vehicle and the injury. But that's why we think in Torres in 2005, the Florida Supreme Court made it a little more clear that there must still be a causal relationship. And we don't have that relationship here. The last thing that I think I would want to mention to you is just from a little bit of insight from my perspective as an automotive defects lawyer in this state, and the cases that we have done. We have seen an increasing amount of these kinds of cases where citizens of Florida are sold products secondhand, particularly automotive products. And when you have this exclusion provided to those types of sales, where you don't have it in the enumerated acts, there are a ton of people in this state who are injured by products who they have no effective remedy for. And we think that the extension of motor vehicle exclusion policies, which don't really talk about these sales or failure to communicate information, we think extension to these sorts of situations is bad public policy and is going to leave a lot of Floridians without any coverage for the injuries that affect them for these products. Because as products get older and unfortunately, as financial times get tougher for many of the people in this state, the sale of secondhand products, including dangerous products, becomes more and more common. So from our perspective, we recognize that there have been lots of cases outside the traditional rubric of what we would think about as a policy exclusion for motor vehicles. We think here this does present a special case, and we'd like the court to treat it as such. Again, though, I do want to make clear that I have no illusions about where this case would head if the trend of how these cases have been decided continues. And that's why we're here today, to ask maybe for some sort of line in the sand about where does the causal connection start and stop. And I think, to the extent that insurance law cases can ever be interesting, this might be one. This is one that's kind of fun to work on because it does raise that novel issue.
Counsel, let me
so
ask you to focus in on the language of the policy a little bit. You responded to Judge Roberts' questions about whether or not this is can fairly be said to be a part of maintenance of the vehicle, but the policy also defines motor vehicle liability as any liability resulting from the ownership of the vehicle, not just the maintenance of it. And so can you explain to me how do you separate the sale of something from the ownership of something? Doesn't the fact that you own it, isn't that sort of a necessary precursor to the ability to sell something? I
think ownership of the vehicle is a necessary precursor to anything at all involving that vehicle, right, for the insured. And so doesn't that in itself mean that it would fall under the enumerated class of ownership of a motor vehicle? We don't think so, because we think that ownership has to have a specific causal meaning in this situation. Because if it meant that any vehicle that was ever owned by the insured that's involved in the incident in any way is excluded, then there's no need for any of the other language. You could just have ownership. But what we believe that ownership in that particular situation means is that the person's ownership of the vehicle must have a causal relationship directly. There must be something about that ownership that creates the accident itself. Because if it wasn't, then there is no need for any of the other language. We don't believe that what this policy exclusion means is that if the person owns a vehicle and it was involved subsequently after their ownership in the incident, that automatically policy exclusion is held, because otherwise we never need to look at anything else in the policy. So we think that
what does it mean then? If it doesn't mean ownership, the language says any liability from ownership of a motor vehicle. So how should we interpret that? What does it mean if it doesn't mean ownership?
One thing I think it should mean is that it should mean ownership concurrent with the accident itself. If the person owned the vehicle and was operating at the time of the accident, obviously the motor vehicle exclusion applies. But prior ownership, where simply the state of ownership had no connection or causal connection with the incident, it was merely a predicate to some other enumerated act. We don't think that that's what the policy is talking about, because otherwise we do think that's amazingly broad. Because once then the insured owns a vehicle, there is no set of circumstances at that time or ever in the future where the policy could apply. And if it was that, it would just be easy enough to write that, to say simply ownership. There would be no reason for anything else in the policy itself. And so that's why we think ownership does not necessarily control this case. And that's my time's running low, but that's all I have for you anyway.
And Mr. Bankston, I'm going to give you an extra minute to give you a little more of your rebuttal time that you were trying to save. And of course, Ms. Ender, you will have an extra minute if you choose to use it. Thank you, Mr. Bankston. Ms. Ender.
Good morning, Your Honors. May it please the court, Catherine Ender from Lewis Brisbois. I'm here on behalf of Citizens Property Insurance Company. We're requesting the court affirm on all grounds because there's simply no coverage for any damages arising from this motor vehicle accident. And this is the exact type of liability that's to be precluded and excluded from this policy. This is a motorhome liability policy of insurance, and the policy exclusion specifically says that excludes motor vehicle liability. This is defined as liability for bodily injury, property damage arising out of either one, ownership, or 2, maintenance, occupancy, operation, or use of a motor vehicle by any person. As counsel conceded, this is not an ambiguous policy provision. Yet, counsel is relying on the case that's been overruled that the 5th DCA came out and specifically said is no longer good law, Westmoreland. And instead, they chose to ignore an entire body of case law that is specifically applicable to what we have here. We have the Hagen case from 1996 in the 5th DCA. And there, the court specifically said, and this was affirmed by the Torres decision later on, the court said the effort to change the focus from the fact that an injury results from the operation of a vehicle is not new. It goes on to say that the attempt to separate the act of negligence from the actual cause of bodily injuries, especially in that case, and similarly under the facts here, is, quote, metaphysics at its best. That's the type of-
But I understand this case to be about not, certainly citizens wrote their policy to exclude car wrecks because, car wrecks are something that you have separate insurance for. But the nature of this claim is that is the sale of the tortious act is the sale of a defective product. Like, if someone sold someone a defective chainsaw, that would be covered under someone's homeowner's policy generally, right?
It could be, Your Honor, yes. But under the circumstances we have here, this case is certainly distinguishable from that circumstance, and this exclusion is distinguishable from other provisions in the policy simply because the reason that Judge Ray explained and the Lake Jackson Pizza case from this court, this is not an issue of concurrent causation. They cannot, the appellants in this case cannot separate the source of the legal duty, which they've alleged to be failure to disclose the danger of the tire or a negligent sale of the tire. That cannot be separated from the ultimate liability for bodily injury that arises from the ownership, use, occupancy, maintenance of this vehicle in this case. This is not a concurrent causation issue. So what the appellants are attempting to do is conflate this tort concept of causation with what the courts have determined to be arises out of and where this liability for bodily injury arises out of. In this case, there's no question, and appellants counsel has essentially conceded that the facts are the facts in this case. We have an unambiguous policy provision, and that the only reason for the liability in this case would be as a result of bodily injury arising from the catastrophic tire separation, which is how it's alleged in the complaint, which happens to arise from ownership, maintenance, occupancy, operation, or use of the motor vehicle by any person. And therein lies the applicable policy exclusion for motor vehicle liability. There's no other set of circumstances that can bring this into coverage. You cannot take metaphysics and place into coverage arguments that there was a negligent sale of a tire 9 months prior to, or I'm sorry, a negligent failure to disclose a dangerous condition in a tire that was placed on a truck 9 months prior to the sale, and then further allege that there was a negligent sale and that none of that arose out of the insured's ownership and that none of the bodily.
So would there have been a different result if Mr. Ogburn was in the business of selling tires and he sold a defective tire that was purchased by Mr. Spradley, and he placed it on the truck, and then it tire separated, he crashed? Would there be a different result, or would that still be excluded from coverage?
It appears from Your Honor's hypothetical that it would still be excluded from coverage if the person who purchased the tire maintained their truck, placed it onto the truck, drove with the vehicle, and had a motor vehicle accident while the tire was on the truck.
Because that seems to be the kind of thing that Mr. Bankston is telling us we shouldn't be doing, because basically we're calling sales of defective products that don't have anything to do with the maintenance or the operation of a vehicle, a motor vehicle accident, when it's a different, there's a different nexus that caused the injury.
Well, Your Honor, I don't think that there is different nexus that caused the injury. There's a legal theory of liability, but ultimately the exclusion is meant to exclude any liability for bodily injury that arises from the automobile accident. And here there would have never been an automobile accident but for the alleged tire separation. This isn't something where you can take out the ultimate legal cause and take that away from the injuries. I'll use the Westmoreland case as an example because that was distinguished by the Fourth DCA later on other grounds. In Westmoreland, there was premises liability allegations for failure to ventilate the garage. And then there were also allegations for improper use of the automobile. And the court distinguished the case there on the fact that there could be a legal cause, and this is a concurrent causation issue where you have a potential legal cause of damages as a result of failure to ventilate, or you have a potential legal cause of the damages as a result of the use of the automobile in the garage. We don't have that here, Your Honor. The only way this accident happened is because there was a tire that blew out on a vehicle while it was in use, and the accident plaintiffs were injured. There can be no other outcome in this case. It's not a concurrent causation issue. And I understand the public policy argument, but it doesn't apply here. This is a mobile homeowner's policy of insurance.
Okay, so let's say Mr. Ogburn had this mobile homeowner's insurance policy, and he had a cell phone that he sold to Mr. Gerganis. And he knew that the cell phone was one of these cell phones that was defective, that would catch on fire randomly. And so Mr. Gerganis is driving down the road with a cell phone in his pocket. It catches on fire and causes him to crash, and it injures Mr. Spradley. Still no coverage?
I think that case would be different, Your Honor, because there you have a set of circumstances, as some of the case laws distinguish that type of fact pattern, where the use of the cell phone in the vehicle, just because the vehicle was the situs of the accident, doesn't mean that it arose out of the use of the motor vehicle. It was as a result of the cell phone that was defective that was ultimately sold. So there, the
what
injuries
matters here is the
occurred.
so-called defective product was part of a motor vehicle, and that makes it subject to the motor vehicle liability exclusion.
Absolutely, Your Honor. The tire was purchased for placement and maintenance onto a truck, which was then driven for 9 months. The truck, including all of the tires, were then sold to Mr. Gerganis, well, his mother, and it was used. And it was through the course of that use that this occurred. The case of Hagen that we cited to is a much more tenuous fact pattern where you have people that are pulling a roll of carpet out of a truck, but using the truck in the process. And there the court, and this was the decision that was approved by the Florida Supreme Court, there the court said, you cannot separate the use of the truck from the actual injuries in that case. And that's the same set of circumstances we have here, less tenuous facts, where we have a truck that was in use. They're alleging that there was a defective tire on it that caused the tire blowout. But all of those circumstances fall within the definition of the motor vehicle liability exclusion in this case. Your Honors, if there's no more questions, it's our position that the use of the truck was not incidental to the injuries. It was an eminently foreseeable consequence of the ownership, use, maintenance of the vehicle, and we're requesting this court affirm on all grounds. Thank you.
Thank you, Ms. Ender. Mr. Bankston, in rebuttal. Your mic's not on.
There we go. I just had one comment to make. I think the court has shown that it completely understands the issues. We have a state of the law where some courts have found different ways on this trend and have gone different ways. But I think the legal issues the court's really in touch with. The thing that really strikes me in this conversation is this idea that you had just brought up, Judge Roberts, that if we apply the policy the way Citizens wants us, you can effectively immunize the sale of a defective product by placing it on a vehicle. Right. So any automotive part that could potentially be defective or anything that could be attached to a vehicle could be effectively immunized under this policy, if that's where we're heading. And I do think that it does bring us back to the policy ideas of public policy, is that when we are in a state where secondhand sales are becoming more and more common, that when the conduct truly focuses on that sale, we would be extremely risky in this state to immunize all of those sales that involve vehicles. And we should really try to focus more back in on what these policy exclusions were originally designed to do, which was to address these specific enumerated acts. And that's the reason that we would like you today to draw a line in the sand and say that the defective sale of a product that was on an automobile and where the alleged negligence is a lack of communicating that danger should not be a basis for this exclusion. So that would be what we'd leave you with today, Your Honors.
All right. Well, thank you both for your argument. It was very good. You really put your issues forth in a very persuasive way. Thank you for the rescheduling, and we are adjourned.
Thank you so much, Your Honors.
Thank you, Your Honors.